Soft law, which is translated as droit souple, droit mou, or even petite source du droit in French, refers to all legal rules that are not officially binding, but are intended to recommend, encourage, guide, define, or serve as a model. But soft law is better understood by looking at what is supposed to be its opposite, hard law. This consists of traditional legal rules that come from a normative authority vested with legislative or regulatory power, and which are mandatory, a characteristic that is reflected in the existence of sanctions. Soft law, broadly speaking, is defined by its non-binding nature and by the absence of judicial sanctions in the event of a violation. In reality, this initial view is a bit too simplistic to be accurate. First of all, soft law is not necessarily devoid of binding force. Rather, it tends to use indirect means to gradually gain the intensity of an obligation. It relies on mechanisms of indirect constraint that exert pressure to conform, particularly in the area of professional or ethical rules. Soft law can thus possess real normative force when it defines standards, serves as a model, prescribes or condemns behaviors, and gradually becomes a frame of reference. A recommendation, for example, may be merely optional in scope and yet still be binding. For instance, the Commercial Code stipulates that a company which fails to comply with the provisions of the AFEP-MEDEF Corporate Governance Code to which it has declared adherence is required to justify itself. It often happens, moreover, that soft law foreshadows the binding norm to come. Such is the case when it is incorporated into hard law. A very clear example of this can be seen with the recommendations of the Basel Committee, which are systematically adopted as mandatory standards. Furthermore, soft law is not without sanctions either. However, these sanctions are often subtle or diffuse. They encourage compliance, such as the comply or explain requirement, which we just mentioned. But these sanctions can also be formidable. This is the case with the practice of name and shame, which can destroy a reputation more effectively than a financial penalty. Civil liability is also a powerful tool for sanctioning soft law, as it allows a failure in behavior to be considered a fault, a failure that is assessed against a standard of reference, which may be defined by ethical or professional soft law norms. Ultimately, the difference between soft law and hard law is not as binary as has long been believed. The perspective on what a legal rule has changed. A legal rule is not only one that ex ante is officially mandatory and sanctioned, it is also one that ex post produces concrete legal effects.